Hello, everyone. I'm Vanessa Antone from the National Association of Criminal Defense Lawyers. And as everyone enters the room and gets settled, I just want to thank you all for being part of this webinar today, this free engage and exchange. I want to remind everyone that it's being recorded so that all of you can watch it later and share it with your friends and colleagues. But that also means that we ask you to keep your microphone muted and keep your camera off until such time as, we ask you to join the discussion or you have a question. And to that end, please also submit your questions through the chat function. And you can look for things that are mentioned during the program in the chat function as well. I will be putting links in. So we want you to participate. Don't forget to use the chat function. And without further ado, we will get started here today. So as many of you know, this is part 2 in the new evidence series, The Busy Lawyer's Guide to Evidence with Rene Valladares, and we are lucky enough to have another installment in this incredible series. If you haven't seen the earlier episodes, you should, and I will be posting the links where you can view all of those recordings. We are also extremely lucky and honored today to have an excellent sponsor again with us, Justice Text. So before we kick off the webinar, I would like to hear a little bit about Justice Text from Devshi Marota. So Devshi, take it away and tell us about Justice Text, please.
Awesome. Thanks so much for the kind introduction, Vanessa. Hi, good afternoon, everyone. My name is Devshi. I'm one of the founders here at Justice Text. We are essentially a tool that's designed to help defense attorneys save time reviewing audio and video evidence. This includes body cam footage, interrogations, jail calls, all of that sort of stuff. I'd love to show you a quick 60-second overview of what the tool actually looks like. So give me 1 second. Awesome. So hopefully you can see my screen all right, but let's say you're an attorney, you just got 50 jail calls for a given case. You can just go into the system, upload them directly from your local file, system, and press transcribe. And after a couple of minutes, what we will do is generate a rough automated transcript of any speech that we were able to detect in that system. And then you'll be redirected to an editor page that looks something like this. And so the cool thing about this editor is that everything is fully editable. It's fully timestamped. Let's say you're scrolling through, a certain section seems to be of interest. You can just click on that and jump directly to that portion in the video. If you want
the address on your license, is that correct?
So as you can see, this transcript is fully synced up with the video file. If you wanted to clip out that section of video to use in a cross-examination or an impeachment or something like that, you could do that super easily as well. You just give a name for your clip, and after a couple of seconds, you'll have a short MP4 file that's ready to go in the bottom right-hand corner. That takes a couple seconds to finish processing, but once it's done, here you go. You have that MP4 file that you can download or share with others.
So this address on your license, is that correct?
So that's a general overview of how Justice Text works. We actually started off as a school project a couple of years ago out of the University of Chicago, after noticing that so much of the tech that was deployed in our justice system was designed to make it easier to arrest and incarcerate. We've been working with defense attorneys since the very beginning and really hope that this can be helpful. Justice Text is $100 per user per month. I'll go ahead and drop my email and the website in the chat in case folks have any questions. And now I'll hand it off to Rene for his amazing presentation.
Well, thank you very much, Devshi. I really appreciate that. And thank you to Justice Text for the sponsorship. And thanks to Vanessa for having me again for this installment of the series. Today, we're going to be talking about objections. And of course, objections is one of the hardest things that we have to go ahead and do as lawyers. Before we get started, everything that we'll go ahead and cover today is going to be is covered at much greater length in my book, A Defender's Guide to Federal Evidence. And in that book, basically what I do is go rule by rule, talk about the black letter part of the rule. Then we provide examples that are defense-friendly examples, defense-favorable examples, as well as, as insight into, how the rule we can apply the rule and that sort of thing. All royalties go to NACTO's fund for criminal justice and the great work they do. And here's my email. If anybody has any questions, or if you want to brainstorm an issue dealing with evidence, please don't hesitate to go ahead and send me a note, and I'll be happily go ahead and touch base with you. So again, as I said a minute ago, objections is one of the toughest things that we do. And it's hard for a number of different reasons. Number one, usually you have some angry judge that's upset that, we're interrupting the flow of the trial, that now the trial is going to go ahead and take longer, that it may cut into their time playing golf that afternoon, whatever. But, in addition to that, they're stressful. Objections are stressful because, according to the rules, we got to do them in a timely fashion. We have to be specific with our objections and that sort of thing. And it is tough. I find it to be tough. And the purpose of this presentation is to go through the primary objections that we can lodge, talk a little bit about them. This is nothing that is going to be like something new that you've heard. Rather, it's more like a refresher on objections, the law of objections, and the principal objections that we can go ahead and lodge. Now, objections are tough, and since they are tough, and also to honor Black History Month, what I'd like to go ahead and do is, through the PowerPoint, through the presentation, honor those that have had the courage to object to unfair systems, and principally our fellow lawyers that have stood up against and have objected against unfair systems throughout the years in this country, as well as some of our colleagues from other countries that have also objected to unfair systems. So with that, we're going to be honoring, folks like Oliver Tambo and Nelson Mandela, and hopefully, they will provide us an inspiration, in that moment in court where we're thinking, oh my gosh, should I object? Should I not object? Well, let's go ahead and again be inspired by people like Tambo and Mandela, and let's object. Now, the way we're going to go ahead and do it, the main thing we're going to go ahead and do today is cover 4 very broad areas. One is going to be the law of objections, the law of preservation of objections. That's in Federal Rule of Evidence 103. Then we're going to talk about objections and the procedure for objections. Then we're going to go ahead and cover the top 10 objections to form. And then we're going to cover objections to substance, the top 10 as well. And what I did is that when we're going from one topic to another, one of this 4 topics, I selected this image. This image will go ahead and be our placeholder for when we're going from one big topic to another. And this is Aisha Evans. You may recall this iconic photograph. This is from 2016. The photograph is entitled "Taking a Stand in Baton Rouge." And that's what we do. When we object, we're taking a stand, and it requires courage. And, I hope that when I'm registering an objection, I can do it in the fashion and the manner that Ms. Evans is doing it in this iconic photograph. And that is, do it in a manner that is calm, in a manner that is collected, in a manner that shows dignity, in the face of all the craziness that's going on around us. Justice is perfectly encapsulated in this photograph. Now, as I said, basically what we're going to be doing is I'm going to be covering the top 20 objections. Now, if you look at many books, many guides, some of them have dozens and dozens of objections. Some of them, have up to 100. And, my view of things is that gets to a point that it's not very helpful. Instead, what I try to do here, again, is focus on the top 20 objections, top 10 as to form, top 10 as to content. And then in doing in talking about these objections, I'll focus on the rule, I will focus on examples, and also on practice tips. Very much like it's done in the book, A Defender's Guide to Federal Evidence, which you can find at the NACTO website. Now, let's go ahead and start talking about the law of objections. It's important to recognize, first of all, the law of objections is not designed to help us. It's not designed to help criminal defense lawyers. If anything, it's slanted strongly in favor, I believe, of the prosecution, who are the ones that typically are introducing evidence. Of course, we do that as well, but typically it's the prosecution that's doing it. And certainly the rules are slanted in favor of the prosecution. Now, let's look at Federal Rule of Evidence 103A. Now, here we're going to be looking at the fact that a party can only claim error if that, as far as the introduction of evidence, if the error affects a substantial right and the party that's objecting timely objects and specifically objects. So you have those two requirements: the requirement of timeliness and the requirement of specificity. And those two requirements are tough. And that, again, you can be in the middle of a trial and, you're wondering, should I object? Should I not? Am I going to irritate the judge? Am I going to irritate the jury or whatever? Bottom line, when in doubt, you have got to object, because the rule is designed in a fashion that if you fail to object, you are putting your client against the 8 ball, because otherwise you end up, basically giving up the objection. Now, under the rule, a party may claim error if the ruling affects a substantial right, only if the error affects a substantial right. So what are things that we need to be pointing as far on the record, trying to establish on the record to show that, in fact, this is a substantial right? Well, as my book here outlines, basically the things that you want to be noting are, amongst the many things that you can be noting for the purposes of the record, is that the evidence that the prosecution is trying to introduce is critical to their case. The more important that evidence is, then the higher chances you have of that ruling, or of that error being effectively preserved and being actionable on appeal. Now, you want to highlight the fact that the prosecution, used this evidence, and the prosecution even potentially used it in closing argument. That the prosecution did it in a fashion that was cumulative. It wasn't just one item in evidence, but, a number of different items of evidence that the prosecution, introduced, which end up being cumulative. Also, you want to point out that the rest of the evidence that the prosecution is bringing in is not overwhelming as far as your client. And you want to point such things as the fact that the court failed to give a curative instruction and that sort of thing. Those are, again, a few things that you want to keep in mind when you're trying to go ahead and either preserve the record, or when you're arguing the error on appeal. Now, so here we're going to be looking at two different, things that we need to concern ourselves when we're talking about preservation. Now, a party may claim error, as I said before, only if the error affects a substantial right. And again, we talked about a couple of techniques or a couple of things to go ahead and look out for in showing that the error does affect a substantial right. And then, first of all, under Federal Rules of Evidence 103A2, if the ruling excludes evidence, the party informs the court of its substance by an offer of proof. So if evidence is being excluded, you have to go ahead and inform the court of its substance by an offer of proof. And hopefully you can do that and insist on doing that outside of the presence of the jury or whatever. But, certainly you need to go ahead and make that proffer, and you gotta make that proffer clearly on the record. Otherwise, you may have a problem on appeal. Now, according to the rules, 103B, once the court rules definitively on the record, a party doesn't need to renew an objection. Now, the problem there is that oftentimes, and some judges are very good at this, they will not rule definitively. They will go ahead and, they will kick the can and they will not make the ruling. And then you have a record that is actually not preserved. So if you're faced with a situation like this, if we're faced with a situation like this, it's critical to insist that the court make a ruling so you got, again, that record preserved for the purposes of appeal. Now, a judge is supposed to conduct a trial so that inadmissible evidence is not suggested to the jury by any means. Now, a lot of times judges can be very careless about this, and prosecutors, can relish the fact that the jury is hearing things that it was not supposed to hear during, during a discussion of what evidence comes in or not comes in. And, again, it is our duty to make sure that, this kind of matters are being handled outside of the presence of the jury. Now, of course, under Federal Rule of Evidence 103E, a court, an appellate court, can take notice of plain error affecting a substantial right, even if that error is not properly preserved. But good luck with that. I mean, good luck with that. That really is trying to go ahead and find cases. And, I very much lived that when I was writing the Defender's Guide to Federal Evidence, trying to find cases where courts have found plain error affecting a substantial right when there wasn't a claim of error by the defense is, trying to find the proverbial, the needle in the haystack. So good luck with that. Again, the way that the rules are set, we have got to object. The bottom line really is, when in doubt, you really have to object. We have to really object as defense lawyers. Now, before we start with our discussion of the different grounds for objection, it's important to keep in mind basically three rules that drive a lot of the objections. And of course, one is Federal Rule of Evidence 401, and that's of course a test for relevant evidence. We'll talk about an objection based on relevance and prejudice later on in our presentation. The second one is its twin, that is Federal Rule of Evidence 403, and that's of course excluding evidence for prejudice, confusion, etc. And then another important rule is Rule 611, which deals with the mode and order of examining witnesses. It deals with the scope of cross-examination. It deals with when leading questions are appropriate, etc. Now, parenthetically, while we're in this slide here, this is an individual here, Hans Litten, who, as a lawyer, had the enormous courage of, when Hitler was in Hitler's rise to power, Hans Litten actually put Hitler on the stand and cross-examined Hitler, examined Hitler in a proceeding. and an unprecedented move that later on in his life ended up, getting him into Dachau, a concentration camp, and Hans Litten, died in Dachau. But again, many of our colleagues, our lawyer colleagues, can provide an inspiration for us in that moment when we're thinking, should I object? Should I not object? At that point, you object. Think of Hans Litten and the courage that he had in examining Hitler on the stand, subpoenaing Hitler. I said cross-examining. He subpoenaed Hitler, put him on the stand. Now, so let's go ahead then and talk about, we talked a little bit about the law of objections under Federal Rule of Evidence 103. And again, the critical thing there is that, the rule really disadvantages us. If we don't object, and if we don't object in a timely fashion, and if we don't clearly state the grounds for the objection, then we're going to have a problem on appeal. Now, let's look at, let's shift gears here, and let's look at the procedure for objecting to evidence. Now, just to rehash some of the things that I said before, but an objection has to be timely, an objection has to be specific, the record has to reflect the ruling. And again, think about those situations, and unfortunately, I've had many situations like that, especially when I was a younger lawyer, where a judge very cleverly will not make a ruling, will go ahead and defer ruling, will kick the can, and then all of a sudden you find yourself with an imperfect record, and a record that you really cannot go ahead and point to in appeal. So the record has to reflect that ruling. If the judge doesn't want to go ahead and make that ruling, the judge wants to defer a ruling, make sure that you press the judge, make sure that at some point you have that ruling on the record, otherwise you're going to have a problem on appeal. Now, if the judge reserves ruling, make sure you renew that objection until you have a definitive ruling, until you have a clear ruling. Now, when the government objects and to your evidence, to your proposed evidence, and that objection is sustained, again, be sure to make an offer of proof. And statistically speaking, objections by the prosecution are significantly more times granted than those of the defense. That's just the way it is. And I learned that again in writing this book, The Defender's Guide, that objections for the defense and objections for the prosecution are treated very differently. And it's good to know that. It's good to know that reality, so we're prepared, and we're prepared to object properly. Now, as far as a procedure for objections, basically this serves as kind of like a sliding scale, so to speak. We start with an objection, then, we move to strike. If necessary, we request a curative instruction, and if necessary, then we move for a mistrial. All right, that's kind of like the 4 steps that you got to think about, that we all have to think about: objection, move to strike, request for curative instruction, motion for a mistrial. Now, so again, we laid a little bit of a foundation by talking about the law of objections. We talked about objection procedure. Let's look at some form objections here. These are objections to form. Now, of course, here's Oliver Tambo and Nelson Mandela, 2 lawyers that, again, can serve very much as an inspiration to us when we're objecting. These are 2 individuals that genuinely objected and spoke truth to power. Now, objection to form. And of course, this PowerPoint is available to you. You will have this PowerPoint. You can go ahead and just use this slide as a checklist. And this is not a comprehensive list by any stretch of the imagination of objections to form, but at least in my view, it's considered to be, or can be considered to be, amongst the top 10. Now, you got here argumentative, asked and answer, assumes facts not in evidence, beyond the scope, etc. We'll talk about, each one of them in turn, and I'll provide some of the classic examples of some of this, objections. Now, let's start with argumentative. Now, and again, the rule that is going to control most of these objections is Federal Rule of Evidence 403 and 611. And that's 403 prejudice versus probative, 611 mode of questioning, control the court and mode of questioning. You certainly do not have to go ahead and cite, the number of the rule. Some lawyers out there are excellent at that. But we don't have to. I'm not necessarily, great at that, at thinking, oh, what's the number and all that. The critical thing is to go ahead and get, and object in a timely fashion and specifically, and state your ground. But here we're talking about objection. This is argumentative. Now, an argumentative questions are not intended to elicit new information. They're intended to argue to the jury. Prosecutors love this. This is an objection that prosecutors love to go ahead and have. And again, this is something that I'm sorry, or this is a line of question that prosecutors love to engage in, and we need to be ready with that objection. Now, some examples are, and you can hear prosecutors saying or making this questions, stating these questions to the witness. Do you mean to tell me that? And of course, this is when we have a witness there on the stand, and prosecutors are asking, questions like this. Isn't what you told this jury ridiculous? Of course, this may be an exaggeration, but you get the point. I mean, this is, you heard questions like this many times before a trial. You wouldn't know the truth if it hit you in the head, would you? That sort of thing. Now, again, here, of course, the objection is argumentative. Now, ask and answer. Ask and answer. And again, this is Hans Litten here in this photograph, and the title of this biography of his is Hans Litten, the lawyer that fought, that trust, that went against Hitler. So objection asked and answered. Asked and answered. Now here, the issue is that the question has already been asked. The prosecutor here is attempting to emphasize the question by repeating it. The form of the question doesn't have to be identical to raise this objection. And the objection applies if the witness has given an answer or the witness stated that they don't know the answer. Still, again, the objection is asked and answered, or also a related objection or a related way of stating this objection is cumulative. Now, another objection that comes here in the form of the questions, and before I talk about the objection assumes facts not in evidence, it's important in distinguishing between objections to form and objections to content or to substance. The two different, I like to separate them because I like to think of them, a little bit differently. Both of them are very challenging, I think. Objections to form are challenging in that typically you're having to make them right on the spot, depending upon, the manner the prosecutor asked the question or the manner that the witness answered, but it's typically right then and there. You have to think quickly on your feet, etc. Objections to substance, typically, you may already have an idea that it may be coming in. So perhaps you may be more prepared, but at the same time, they are more complex to make. You need to go ahead and be able to master the law of that particular objection a little bit better. So, I separate them because while both categories of objections are important, they operate a little bit differently. They're both challenging in their own way. One, because again, you have to be making them more on the fly in response to the type of question or the type of answer. For objections to substance, you perhaps are a little bit more prepared to make that objection, but at the same time, the objections tend to be a little bit more complex. Now, assumes facts not in evidence. All right, so a couple of things about this one here. Now, this is your typical, when did you stop beating your wife, when there's no evidence that that witness has ever done that, okay? And again, this is a typical question or a formal question that prosecutors love to go ahead and make. Now, not only is this objectionable because it does assume facts not in evidence, in addition to that, there's an ethical component to it. And as far as the ABA standards of criminal justice, prosecutors should not ask a question which implies the existence of a factual predicate for which there's no factual basis for belief. Okay, and again, this is a prosecutor favorite doing this sort of thing, and we need to call them on it. Not only is it objectionable because it assumes facts not in evidence, in addition to that, also it is really unethical. And here I got the Adair case. This is a Seventh Circuit case, and this is a good case for when the government is asking a question for which they lack good faith basis. In this case, it was a tax fraud case. Now, and here the trial court erred by allowing the prosecutor to ask a series of questions for which the prosecutor had no basis for. Now, so here we go into a different type of objection. This is beyond the scope. This is outside of the scope of examination. Now, this is a favorite objection of prosecutors. We're doing a cross, and the prosecutor will object beyond the scope of examination, beyond the scope of direct. Now, we can certainly lodge this objection if the prosecutor is engaging in a line of examination of one of our witnesses and they're going beyond the scope. But oftentimes what happens is the prosecutor will go ahead and object to our line of questioning as being beyond the scope of direct. Now, in that instance, we need to keep in mind that the scope of cross is very broadly defined. And if we're having to meet that objection, if the prosecution, is making that objection, a couple of things that can help us in trying to meet that objection. And again, one is that the scope of cross is very broadly defined, and it's defined to encompass questions that challenge or explain direct testimony and any conclusions or inferences drawn from that testimony. So we have the right to go ahead and engage broadly in cross-examination of any topic that may encompass the questions that fairly come in the scope of direct examination. In addition to that, as a second point, is that we also have the right to test the witness's bias, interest, memory, motivation, or perception. We have the right to test that. That is never beyond the scope of examination. That is always a right that we have. And a great case for that is Davis versus Alaska, where the Supreme Court said that the exposure of a witness motivation is a proper and important function of cross-examination. Okay. So again, when the prosecutor is objecting beyond the scope, these are two things that are important to keep in mind. One, the scope of cross is broadly defined, and second, we always have the right to test bias, interest, etc. Now, this is another case that is really good for our side when we're examining, when the prosecution registers an objection to our examination that is beyond the scope, then this is a good case to go ahead and talk about how an undue limitation on cross-examination violates the confrontation clause if it prevents the defendant from exposing bias, motive, incentive for lying, eliciting testimony, etc. This can be very helpful, especially when we're examining an informant and that sort of thing. And again, this goes back to Davis versus Alaska, but this is a Ninth Second Circuit case, fairly recent, that gives us the right to go ahead and test that witness for to expose their bias, motivation, etc. Now, this is something that it's useful to keep in mind. But according to Federal Rules of Evidence 611, a court may allow an inquiry into matters that are outside of the scope of direct examination. But when that happens, counsel has to proceed through direct examination. So if you have a prosecutor that is redirecting and is say exploring areas that are beyond the scope of direct, of course, that's objectionable in and of itself. But then if you also have a prosecutor that is pursuing areas that are beyond the scope of direct of one of your witnesses, you have a witness on the stand, prosecutors crossing, prosecutors going beyond the scope of direct, and the court allows them to do that. You already objected to that. You already objected to the fact that it's beyond the scope. The court overrules your objection. The court allows the prosecutor to proceed with that line of questioning under Federal Rule of Evidence 611. If the court does that, the prosecutor has to phrase their objections as if they're doing a direct examination. They cannot do it as if it is a cross-examination. Okay, now, another one here that oftentimes we have to use, and that is a compound question. Prosecutor is on direct examination. Prosecutor is asking a question. That question is compound. The question is confusing to the jury. And, typical examples, of that is, classic examples of that are, wasn't the jury, the fire truck, driving westbound and flashing its lights. So you have two different items right there, two different, factual components there. One is driving westbound, another one is flashing its lights. That's a compound question. That question needs to be broken, apart. Same thing on that day. Did you go to Target in the morning and Home Depot in the afternoon? That's objectionable. And again, prosecutors oftentimes will go ahead and engage in that type of questioning. Now, this is usually the result of sloppy questioning on the part of a prosecutor, not necessarily, a calculated type situation like when did you stop beating your wife? They assume facts in evidence type objectionable question that we discussed a few minutes ago. So this is typically a result of sloppy questioning. The advantage, of course, of launching an objection when you have a situation like this is that, it may derail the prosecutor. And if you have a prosecutor asking sloppy questions, it's because a prosecutor is a sloppy examiner, and launching an objection may actually derail their line of questioning, and it may end up, benefiting, our client, and it may end up, furthering our goals in the trial. Cumulative, that's another one of the objections, and of course, this one here, is evidence that that a question is cumulative when its subject has already been covered, it's been covered by other questions, it's been covered by other exhibits, and that sort of thing. The question is, at that point, cumulative. And again, to emphasize the objections I'm talking about right now, these are objections that are to the form of the questions. Soon here, we're going to be talking about objections to the substance of the questions. Now, another objection is harassing the witness. Now, this is something that you often see when we put a witness on the stand. You have our client's mother, you have our client's wife, whatever it may be. And then you have, a prosecutor that's being a bully with the witness, and the prosecutor is, either repeatedly asking the same questions, or rudely phrasing the questions, using sarcasm, yelling at the witness and that kind of thing, embarrassing the witness, well, that's harassing the witness. And unfortunately, this is the kind of thing that you see a lot of times. You have, and you can see the prosecutor, you put your witness on the stand. And again, that's a friend, a relative of your client, whatever it may be, or perhaps just some, poor bystander that happens to, to further your cause. And then immediately the prosecutor assumes, this look of, a sarcastic look, a condescending look, and, and engages in a line of questioning of that witness when they're crossing, that witness that is, very sarcastic, very rude, and that sort of thing. Harassing the witness there is the right objection. And that's a very valuable objection for us, as if you can lodge it and you get the court to go ahead and rule in your favor, or even if not, then the jury can see, and can look at what the prosecutor is doing, and that can be certainly beneficial to our side. Leading, of course, that is another, something else that we need to be, very careful with prosecutors who often will go ahead and lead. Now, leading, of course, should be, this is, basic black letter law, and it's right in 611, Federal Rule of Evidence 611. Leading should not be used on direct examination. And the rule allows leading questions in several circumstances. When you have, for instance, cross-examination, number one, when you have a hostile witness. And then, of course, case law allows leading questions when you have a witness that, may be infirm, that may be young, if they, and here's something that we need to be careful about, because oftentimes, prosecutors will go ahead and engage in leading, and and then we object, and they say, well, Your Honor, this is a matter that's preliminary. Well, true, the case law says that leading questions can be posed in preliminary matters, but oftentimes prosecutors stray far away from that and engage in improper leading when topics are certainly not preliminary, and we need to be ready to go ahead and object. Now, one of the things that's very important is that this applies to oftentimes when we are leading, is that, and again, here you see that distinction between courts ruling favorably for the prosecution when in theory, when the prosecutor is the one that is objecting to us leading, versus when we're the ones that are leading. So this distinction here is important to know. A leading question is one that puts a desired answer in the mouth of the witness by suggesting the answer. Now, so you have, at what time do you see Michael? That's perfectly fine. Now, let's look at the ones below. Now, oftentimes you'll have a prosecutor phrasing a question like this: you saw Michael at 3 p.m., right? Well, that's leading. Now, we say are the ones that now are questioning a witness on direct. And we ask a question like this one at the bottom: did you see Michael at 3 p.m.? And the prosecutor will stand up and object leading, especially if we have done the same to them. Then the prosecutor is just, waiting for the chance to object when they think we're leading. And we ask a question like that at the bottom: did you see Michael at 3 p.m.? And that question, of course, is different from at what time did you see Michael? But still, we can argue that that question at the bottom is perfectly appropriate. It is not suggesting the answer. Yes, it wasn't phrased like, at what time did you see Michael? Where you have, the one of the W's, when, why, what, etc. Here you have, did you see Michael at 3 p.m.? That question is not suggesting its answer. It should be perfectly fine, and you can respond that way to the to the prosecutor when the prosecutor is objecting to your question as it being leading. It is not leading. All right, now narrative. So the prosecutor has the agent on the stand, and then the prosecutor will go ahead and ask a question like this. I mean, this is something that happens in almost every case in the federal system. Tell the jury how you went about investigating the case, or tell us everything you did on that day. My gosh. And then here you have, the witness, going on and on and on about what happened, about, how they went about investigating the case and that sort of thing. Of course, that, that witness there is engaging, or that question calls for a narrative answer. That's objectionable, and the objection there is narrative. Objection vague. And an example of that is at the bottom. When do you leave your house in the morning? And again, this type of objection we can often lodge when you have a sloppy prosecutor. Oftentimes prosecutors think that they can go ahead and start asking questions and they'll get away with whatever, because they typically do. So here, you have a sloppy prosecutor asking a question like the one at the very bottom of the slide. When do you leave your house in the morning? And of course, that's objectionable, that's vague, it doesn't specify, what day are you talking about? Are you talking about on Mondays? Are you talking about it on the weekends? And that sort of thing. The objection there is that, this question is vague. Now, so, objections to content. Let's go ahead and start talking about objections to content. Before we do that, again, talking about an objection like this one here, like objection vague, or like the objection that I talked about a few moments ago, compound. Oftentimes we may think, well, is it really worth objecting? Is it going to upset the jury? Whatever. And when you have a question like this, when do you leave your house in the morning? Well, first of all, is that the witness may end up, giving an answer that may hurt us. But in addition to that, we may want to launch that objection because you got a sloppy prosecutor who's not thinking about what they're doing. You launch that objection and it derails that prosecutor. It may go ahead and make that prosecutor stop and, lose their train of thought and that sort of thing, because they are in fact, asking a question that is a sloppy question. And we have the right to go ahead and launch that objection there. But oftentimes they will go ahead and benefit us to again have the prosecutor lose their train of thought. At any rate, let's go ahead and get into objections to content. Now, here, I placed like 10 of what I think are the top 10 objections to content, objections to substance. Now, and here we're going to be covering such things like, hearsay, improper character, improper opinion, etc. Now, some of these areas here I have handled in standalone presentations, like Vanessa was talking about earlier. Last year, I did 2 presentations on hearsay, did 2 presentations on character evidence. Those are available to you, where we're talking about hearsay and character evidence in a much more granular fashion. Obviously, I'm not going to be able to go ahead and do that here. In fact, I'm going to really speed up through them. But I do want to cover some of the principal objections to, say, hearsay or character evidence. In addition to that, at the last presentation that I did, the one I did in January, and that was a framework on evidence, I did cover hearsay, I did cover character evidence, and I did cover opinion testimony. That recording also is available to you. And I did it in a manner that is significantly more abridged than in the standalones for presentations on hearsay or standalone on character evidence. But I did cover hearsay, character evidence, and opinion evidence in more depth than what I'm going to be doing, today. At any rate, these are objections again to content, to substance. Oftentimes, you may have somewhat of an advance notice on this one. The discovery, is going to show you, for instance, that that you may end up with a statement that you're going to have to object to, if it's hearsay, or that you may have improper character evidence and what have you. And of course, one of the things that we need to consider is that, should we be engaging in limine litigation, filing motions in limine to try to go ahead and address these matters prior to trial. Now, we are, however, now in the middle of trial and we're having to object. Now, let's go ahead and look at hearsay. And again, just to emphasize, I do have prior recordings where I'm covering this topic at significant, length. I'm going to cover it here in 10, 15 minutes. And those presentations I cover actually altogether in 4 hours. So, here pretty quickly, we're going to go ahead and talk about, 3 areas when it comes to hearsay. We're going to talk about hearsay definitions. We're going to talk about hearsay exceptions. And we're going to talk about hearsay exclusions. Now, so let's start with an approach to hearsay. And, this is something that I featured in prior presentations, this little flow chart here. First of all, we start with, is there a statement? Is the statement offered for its truth? Is the statement a hearsay exclusion? That is not hearsay under the rule, under Federal Rule of Evidence 801D, or, is the statement an exception to the hearsay rules under Federal Rule of Evidence 803 or 804, depending upon whether the availability of the declarant is material or immaterial. And then, very briefly, we're going to go ahead and also, we need to also look at, does the statement violate the confrontation clause? Now, hearsay definitions. Now, a declarant, we have a definition of hearsay is a statement made by a declarant, an out-of-court statement made by a declarant, offered for the truth of the matter asserted. Now, let's look at a couple of things here. As I said in prior presentations, a declarant has to be a human declarant. Fido the dog or Polly the parrot don't count. The fact that the statement is being made on the stand, repeating something that witness actually said out of court, that still makes it hearsay, even if it is the same witness that's repeating an out-of-court statement. That's still hearsay. Now, it may come under an exclusion, it may come under an exception, it may be used not for the truth of the matter asserted, you name it, but still, it needs to be analyzed under the hearsay rules. And we need to look at, does it fall under the hearsay definition under 801C? Now, the main thing we're going to be looking at when we have a statement, and as I said in prior presentations, typically a question is not going to be a statement. Typically, a command is not going to be a statement. But the critical thing that we look at is that, is it being offered for the truth of the matter asserted? Now, here is an area where we really not need to be aggressive as far as objecting, because this is a fallback position that prosecutors love to take. We object and prosecutors say, well, this is not hearsay because we're not offering it for the truth of the matter asserted. Instead, the prosecutor will say it's offered, say, to show course of investigation. Now, something is not for the truth of the matter asserted if, in fact, it's showing to it's being presented to show course of investigation. If it's being presented to show effect on the hearer or reader, if it's being presented to show knowledge or to impeach. All that is very true. And again, prosecutors love the first one, that is course of investigation. And they frequently will go ahead and use that basis to try to justify why a statement doesn't fall within the hearsay rule, as I said a moment ago. They say, no, Your Honor, this is not hearsay because it is not offered for the truth of the matter asserted. It is not offered for the truth of the matter asserted simply because it's being presented to show course of investigation. I mean, this is something that prosecutors just love, and they constantly do that. Rarely will you be in trial without prosecutors attempting to go ahead and do that. Now, I've discussed this case at length in prior presentations, but this is an excellent case, the Becker case. This illustrates the point of how prosecutors abuse, exploit course of investigation. And this is a nice case, if I can just touch upon it really quickly here. But the bottom line is that if a statement goes to the heart of what the government is required to prove, that is going to be hearsay, and it cannot be disguised. It cannot be window dressed as being background information, like prosecutors will often will love to go ahead and argue. This is, of course, a painting here of John Brown being taken to the gallows after being convicted, and in doing that, he stops and actually and kisses a slave boy. It's an amazing, picture. Talk about somebody that objected, to systems of justice that were unfair, that were oppressive, that were really truly disgusting. But talking about that case here, here the defendant, is convicted of drug firearm charges. At trial, an officer testifies that an identified CI told him that the defendant was selling meth, manufacturing hash, etc. And the informant talks. I'm sorry, the agent talks about this, at length. Defendant objects. The prosecutor says, no, we're simply using this not for the truth of the matter asserted. Instead, we're using it to show course of investigation. And the district court lets it in. And here the 10th Circuit says, no, this went to the very heart of what the government, needed to prove. The statement here by the agent went to the very heart of the case. In addition to that, the government used that statement in closing, meaning the government was not simply using it to show course of investigation. They were using it for its truth. They were using it to show that the defendant, in fact, was guilty of like the informant had said, selling methamphetamine, manufacturing hash oil, etc. A nice case here. And going back to what we were talking about initially about preservation of the record, these are the kind of things that you want to be putting on your record. This goes to the very heart of the government's case. This is an argument that the prosecutor say, you object. You say, this goes to the very heart of the government's case. The court denies you for your objection. Listen to evidence. Later on at trial, the prosecutor, the prosecutor talks about that in closing argument, talks about the statement made by the agent, say in the Becker case, where the agent parroted what the informant had said about the defendant manufacturing hash, the defendant selling meth. So the prosecutor now is on closing argument. This is not anymore in direct examination. This is in closing. Object again. If the prosecutor is using that in closing, well, it's clearly not for the truth of the matter asserted. So what they told the excuse they gave the court initially, that this was for simply the course of investigation, that's a lie. That's not true. They were using it for its truth. they were using it to show not course of investigation, but rather, that in fact, the defendant was guilty of that our client was guilty of that. Now, all right, so still on the topic of hearsay, one of the main things that we need to watch out for is hearsay exclusions. Now, in hearsay exclusions, we're going to have a number of different hearsay exclusions under the rule. It's going to be 3 that we need to watch out for, and it's a prior inconsistent statement, a prior consistent, it's actually more than that, a prior consistent statement, and then we're going to have also statements of identification. But then we have, as far as hearsay exclusions under the rule, the more important thing we need to watch out for is basically admissions. Admissions by either our client or adopted admissions or what have you. And the worst one of the bunch, is our co-conspirator statements. These are, co-conspirator statements are another thing that prosecutors love to bring in. The rules of evidence, lets them in like a Mack truck. They're really unfair, so it's an unfair treatment of the statements for us in the rules of evidence, but nonetheless, there you go. They are under Federal Rule of Evidence 801 D2E. And under that rule, this is a hearsay exclusion. The prosecutor hasn't even had to submit them to a hearsay exception analysis. If a prosecutor makes an argument, oh no, this is a co-conspirator statement, that is a hearsay exclusion, and the rule excludes those statements from even being considered hearsay. Now, we need to watch out in the context of co-conspirator statements that the co-conspirator statement has to go ahead and be in furtherance of the conspiracy. Idle conversation is not enough. Idle chatter is not enough. Casual conversation is not enough. And again, in prior presentations, I'll talk about this at great length. But let me just recap a case that I like and talk about and have talked about in prior presentations. And this is the Darwish case. This is a Sixth Circuit case. And here what happened is that this is a conspiracy case to distribute marijuana. And what happened here is that the government presented a witness who testified that his nephews had talked to him about the defendant having, a marijuana distribution operation at his convenience store, and how the defendant employed the witness's nephews to bag and package marijuana. And this witness had testified to the procedure and how they bagged the marijuana, his nephews bagged and the marijuana for the defendant, and testified also about how much they were bagging as far as marijuana is concerned for the defendant. Now, the defendant objects at trial. The defendant says this is hearsay. The prosecution says no, this is not hearsay. This is a hearsay exclusion. It's a hearsay exclusion because this is simply a co-conspirator statement. And the defense says no, this is just idle chatter. This is the co-defendant, so the defendant, repeating something that is not at all for the purposes of furthering the conspiracy. This is just a casual conversation between these two co-defendants, the nephews of the witness on the stand, and the witness. And the witness is now repeating what his nephew said. The prosecutor is arguing, oh no, this is a co-conspirator statement. This is an exclusion to the hearsay rule. there's no need to even analyze it under a hearsay exception. We'll get to exceptions in just a second here. Here, the district court lets it in, despite the fact that, the defense counsel had objected, had stated its grounds and all that. But the Sixth Circuit says, no, this is simple, idle chatter. This is not in furtherance of the conspiracy. So bear this case in mind when you're objecting to co-conspirator statements, because oftentimes what the government's trying to bring in is just junk. It's nothing more than, again, casual conversation that is not in furtherance of the conspiracy. And for a statement to qualify as a co-conspirator statement, it has to be in furtherance of the conspiracy. And this is a good case to show that. Okay, now, so as I said before, what we end up having here is under hearsay exclusions, we have statements of the defendant or adopted statements or co-conspirator statements. We also have prior inconsistent statements. And if the prosecution is trying to use them, one of the things that you need to look out for is that a prior inconsistent statement has to be made in the context of a proceeding. And as I said in prior presentations, a station house questioning, even if it's recorded by either tape recorded or even if it's recorded by a stenographer, doesn't count. That's not in the context of a prior proceeding. It's just a station house recorded. Now, as far as objections, when it comes to the government saying, oh no, this is a prior consistent statement, and consequently, this is a hearsay exclusion, then, be on the lookout for the fact that a prior consistent statement has to be made before the time came up before the witness had, or the individual that the declarant that made that statement had a reason to fabricate. So if what the government is talking about are statements made by the informant, for instance, made by the informant to the police after the informant started already collaborating, started already cooperating with the authorities, and the government is saying, oh, this is a prior consistent statement, and the government is trying to get the agent to repeat what that informant said, and you object, and the government says, oh, this is simply a prior consistent statement. The agent's testifying to that because that's what is consistent with what the informant said on direct examination. After in cross-examination, say the informant was crossed by you. Now the government saying that this statement simply goes to rebut a claim of recent fabrication. That's not the case. They don't qualify under the rule. The informant by then was already collaborating. The informant was cooperating already. The informant already had a motive to lie. Consequently, that does not qualify as a prior consistent statement under the rule. Lastly, as far as statements of identification, always bear in mind that, we need to bear in mind that while this rule is really broad and let's say in a bunch of, stuff that in my mind is junk, even if the witness is testifying and identifying your client on the stand, out-of-court statements can come in under this hearsay exclusion. Still, remember that we can challenge those statements for their lack of for their unconstitutionality because they're suggestive, for instance. Okay, now let's talk briefly here about hearsay exceptions. And of course, I deal with hearsay exceptions at great length in prior presentations. There's a total of 28. We're just going to be covering really briefly some of the top ones. Like I said, we are covering in this presentation the top 10 objections to form, top 10 objections to to content, to substance, and within the hearsay objections, that's the first that we're dealing with when it comes to content. Here are, we're going to be covering the top 10 hearsay objections. And amongst them, we have present sense impression, excited utterance, state of mind. I just want to say a couple of things, about these objections. And again, they're covered at much greater length in prior presentations. So let's start with present sense impression. So if you're having to objection, hearsay, and the government says, oh no, this is not hearsay because it comes under the hearsay exception under 803.1, present sense impression. Now, amongst the things where you can push back, are the, first of all, it has to go ahead, the statement has to be nearly contemporaneous. And oftentimes the prosecution will try to bring in statements that are not nearly contemporaneous. They make 10 minutes after, half an hour after, an hour after. That's not nearly contemporaneous. If on the other hand, you're the one that's trying to bring this statement and the statement qualifies in the present sense impression, oftentimes the prosecution will object and say, no, this is not, there's nothing to object here. This is not hearsay, it's present sense impression. And then the prosecution will go ahead and say, oh yeah, but it was not in response to a startling event. Well, that had to be one. It doesn't have to be one under this rule. So if you're defending, that objection, if you're defending that evidence in the face of a prosecution objection, and the prosecution is saying, that the statement doesn't fit under this exception to the hearsay rule because the statement that's being described is not startling, that's an improper objection on the part of the prosecution. The statement doesn't have to be startling under this rule. Then you have excited utterance, and here you enter an objection, and oftentimes prosecutors will go ahead and confuse this with the prior one, with present sense impression. So here the event has to be a startling event. Okay, again, oftentimes prosecutors will go ahead and they'll confabulate both. And the reason they will is that they'll say, they'll argue excited utterance, because excited utterance doesn't have the same time requirement that present sense impression has. So if one of the prosecutor witnesses is making was repeating some statement made by somebody else or by themselves, at a court, a statement that otherwise would be hearsay, and they're trying to excuse it under an exception, but the prosecutor knows, oh, geez, this statement really was not made contemporaneously. So oftentimes what the prosecution will argue is that, oh, but it's an excited utterance. But oftentimes it will not be in response to a startling event or condition. If it is not in response to a startling event or condition, then it doesn't qualify. Okay, then existing mental emotional condition. And again, here what you have is that the things to watch out for. You're objecting, hearsay is your objection. The witness on the stand is saying something that somebody said out of court or repeating something that they themselves said out of court. And the prosecutor says, well, Your Honor, be it as it may, this comes under a hearsay exception. The hearsay exception is then existing mental or emotional condition. And according to the rule, of course, if a statement that describes state of mind, motive, intent, plan, or an emotional or physical condition, then it falls under this rule. And then according to the prosecution, then it falls under this exception and the statement comes in. Well, not so fast, because this kind of statements do not include a statement of memory or belief. And oftentimes prosecutors will want to bring it in precisely to show, to include a statement of memory or belief. And under this rule, that's improper. So for instance, the statement, I'm scared, that's okay, that can come in, that comes in under the rule. It's a statement that describes an individual state of mind. But, I'm okay because I'm scared because I was afraid of the defendant. I'm scared because the defendant threatened me. That is not okay. That is a statement that includes a statement of memory or a statement of belief, and that's not okay, and that should be excluded. That does not fall under an exception of the hearsay rule. So again, this is something to be on the lookout when the prosecution is invoking this this exception. Okay, you can come back and say, no, this doesn't fall under the exception because it is a statement of memory or belief. Statements of for the purposes of medical diagnosis or treatment, this is another exception under the hearsay rules. Oftentimes, prosecutor may try to introduce something based on the purposes of medical diagnosis or treatment, a lot of times in a sexual case, sexual abuse case, and that sort of thing. So you object, your objection ground is hearsay. Prosecutor comes back and says, well, this is for the purposes of medical diagnosis or treatment. The statement was made for the purposes of medical diagnosis or treatment. And true enough, this is an exception. The exception is actually quite broad, and it covers a statement made to a doctor, it covers a statement made to a nurse, it covers a statement made to a psychologist, and under those circumstances, it's a statement that that could have been about a prior physical or mental condition, you name it. So long as it's being made for the purposes of diagnosis or treatment, it comes in. It comes in under this exception. However, prosecutors often want to bring in this sort of a statement to tie it in to identification, the identification of our client, the identification of the defendant. And that is improper. So a statement that identifies the perpetrator is usually excluded under the rules. So a statement that assigns fault or identifies a perpetrator is usually excluded under this rule. So a statement, I was shot. The statement to a doctor, I was shot. With a rifle. That may come in under a statement that for the purposes of medical diagnosis or treatment, but the follow-up, I was shot. Again, this is an out-of-court statement, of course. If the individual is describing what happened on the stand, that's a whole different story. But if either that individual is repeating a statement made out of court, or another witness is repeating the statement made by a different witness on the stand, and again, I was shot here, in this case, I was shot by Rene with a rifle, that does not come in under this rule, because that statement identifies the perpetrator, and usually that should be excluded, okay? So while indeed a statement comes in for the purposes of if it was made for the purposes of medical diagnosis, it comes in, it does not come in if it identifies the perpetrator. So a portion of the statement, at least, that identifies the perpetrator does not come in. Some courts have made an exception to this when it's a situation where you have like like child sexual abuse, and say the defendant is a parent or a relative that lives in the home. But that is a very rare exclusion to this rule. Typically, a statement that identifies the perpetrator does not come in under the excuse of medical diagnosis. Very briefly, just remember, obviously business records is an exception in many types of cases, especially fraud cases. Prosecutors, very liberally avail themselves of this exception. Same thing with public records. The thing for us to keep in mind if we're doing the objecting is a number of things. First of all, you can object that the method of preparation of the records, that the method of keeping the records lacks trustworthiness. That's a very important, ground for objection. In addition to that, if the document, if the exhibit, if the business record was prepared in anticipation of litigation, that is outside of the rule. That does not come in. In addition to that, look out for hearsay within hearsay. So if you have one of these cases where there's a ton of discovery, say on a large fraud case or whatever, and prosecutors trying to bring in all kinds of records and stuff, keep in mind those three potential sources for us objecting when the prosecutor invokes the business record exception to the hearsay rule. So a prosecutor trying to get all these records, we object hearsay, prosecutor says business record, an exception, then we can come back by saying, well, the preparation of this records, does not have indicia of trustworthiness. Instead, it lacks trustworthiness. In addition to that, the records cannot be prepared in anticipation of litigation. That's objectionable. And moreover, look out for hearsay within hearsay. All those are pressure points that we can apply. And same thing for public records. Look out for anticipation or a record being produced in anticipation of litigation, a record that contains hearsay within hearsay, and the opponent, or the records lacking trustworthiness. So those are pressure points that we can apply when we're faced with either business records or public records. Let's remember also the law enforcement exclusion when it comes to public records or business records, that prosecutors cannot be, claiming the business records or the public records when it comes to law enforcement reports. They are not covered by the rule. In fact, the rule 8038, when it comes to public records, makes it very clear that law enforcement reports, reports of investigations cannot be used. They do not qualify. Of course, absence of a record is another thing that the prosecution often tries to use, and in trying to show such things as failure to file a tax report, in tax evasion cases, or failure to obtain a firearms license in those kind of cases, in improper dealing in firearms, etc. One of the things that again we can always try to object with is objection hearsay. Prosecutor response, well, but this comes under absence of the record. There is no record showing that this person filed a tax return or obtained a firearms license or obtained an immigration permit, a visa, or whatever it may be. We can always argue lack of trustworthiness. The way those records are kept is deficient. We can also point to not just the way the records are kept, but also the fact that the search of the records was a shoddy search, an imperfect search, and that sort of thing. Now, so let's talk really quickly about hearsay exceptions when we're talking about unavailability. We're really quickly going to cover dying declaration and statements against interest. That gives us within the objections to substance, and within that category, the subcategory of hearsay objections, this rounds up to our 10 hearsay objections, dying declaration, statement against interest. For dying declaration, remember that the case has to be a homicide case, while the declarant believes death is imminent. And concerning the cause of death, of course, these are, it's very rare that you will see this type of situation. But for the statement to come in under this exception, again, it's got to be a homicide case, and the statement must have been made while the declarant believed that death was imminent. Statements against interest, these are much more common than dying declarations. For this, just like for dying declarations, if the government is trying to bring in these statements, the government has to show unavailability, and that is a difficult threshold. The government has to show that that they could not, after diligent efforts, subpoena the witness, and it's diligent efforts. It's not simply that the prosecutor was asleep at the wheel on the last minute, tried to subpoena the witness, and the witness didn't, they couldn't reach the witness because the prosecutor had the agent try to subpoena the witness the day before trial. Well, that's not diligence, and that would not be unavailability. Same thing for the other grounds for unavailability. The witness's refusal to testify, it has to be a clear refusal after a court ordered the witness and that sort of thing. Same thing with a privilege. There has to be a clear invocation of the privilege prior to there being unavailability. But let's say that the prosecution is able to establish unavailability, then the prosecution is trying to avail themselves of this exception to a rule, and for it to come under this rule, the prosecution has to establish that the statement is contrary to the declarant's pecuniary or proprietary interest. Now, in a very unfair fashion, the rule demands that if we are trying to use that statement, so if we're trying to use it, an out-of-court statement, because that out-of-court statement exculpates our client, and instead it inculpates somebody else. Yeah, I was the one that shot, not Joe being the defendant. Then we have to show circumstances that indicate trustworthiness, and oftentimes court put near impossible hurdles for us being able to show that. Now, but that should not be the case. If any statement, so long as it's being made in a fashion where it would subject that individual to their pecuniary or proprietary interest being jeopardized, should fall under this rule. By the way, next month I'm going to be giving an evidence update, talking about new rules that are in the pipeline. I want to be talking about this rule, and I'm going to be talking about some potential amendments that may be coming that may actually be favorable to us when it comes to this rule, especially this whole business about having to show corroborating circumstances clearly indicative of trustworthiness. So stay tuned. We're going to have a presentation of that next month. I hope that you can join us for that. Really briefly here, it's important to keep in mind the distinction between both party admissions and statements against interest. Party admissions have to be made by a party and do not have to be made against interest. They don't have to be made against interest. Statement against interest can be made by anyone, but they do have to be indeed made against interest. And the declarant has to be unavailable. For party admissions, the declarant does not have to be unavailable. Very importantly, and again, I've talked about this in prior presentations, always remember Federal Rule of Evidence 806. The prosecution has presented hearsay evidence. They were able to convince the judge that a statement can come in. You know, this is under a hearsay exception. Remember that hearsay declarant can be impeached. You can actually attack their credibility. You can go ahead and present, evidence that witness is has a reputation of being a liar. You can go ahead and present evidence of that declarant's prior conviction, etc. So the government, manages to get in hearsay evidence in, you can impeach that declarant, the declarant that made that statement out of court. You can impeach them as if they were any other witness under Federal Rule of Evidence 806. Now, it's important to note that, again, a hearsay objection will not preserve a confrontation clause challenge. Now, let's go ahead and shift gears, and let's go from hearsay to improper argument as a grounds for objection. Here I lay out within improper argument, 10 of the most typical objections, 5 for opening argument, 5 for closing. For opening argument, you can argue that it's argumentative, that it's giving a personal opinion, that it's discussing the other side's evidence when the evidence hasn't even come in. It's opening. That it violates the golden rule or vouching. Same for closing. These are the top 5. And again, you have this PowerPoint is available to you. Vanessa will make it available to you. So you can use this as a little handy checklist. But you can object to misstating the evidence, giving personal opinion, golden rule, and certainly vouching. Now, let's talk about improper character impeachment. With this slide here, it's important to note that many of our colleagues in other countries, especially, are many lawyers are detained and they're prosecuted for being lawyers and for representing their clients and all that. And I find it to be very inspirational how lawyers in many other countries have the courage to go ahead and put everything at risk to serve their profession and their clients. So character, really quickly doing a character review. Again, remember, this is certainly a topic that we've covered at great length in prior presentations. There's a total of 4 hours of character evidence that we discussed in prior presentations, like Vanessa mentioned earlier. But let's look here at the component of attacking character evidence. So we start with the fact that the first argument we make is that this is simple propensity evidence, and of course the rules prohibit propensity evidence. Somebody should not be judged based on what they've done or on who they are, but instead it should be judged for what they're supposed to have done in this particular case. That's the propensity prohibition, and the rules are supposed to further that. Now, there are exceptions to a propensity prohibition in a criminal case under the rules. Let's remember that there's the evidence of defendant's character, evidence of the victim's character, and also let's remember that there's the limited use that we can have of the victim's sexual behavior or disposition. Reviewing this really quickly here, remember that we have the right under the mercy rule, which is an exception to a propensity prohibition. we have the right to present evidence of our client's good character. But let's remember also that the government has the right to rebut, and that can cost us very dearly. Also, we have the right to present negative evidence of the victim's character. But let's also remember that the prosecution under the rules has the right to go ahead and rebut, and that also can cost us, dearly. So we need to be careful about that. So those are exceptions to the propensity prohibition in a criminal case, and those are triggered by us. We actually have the right to go ahead and circumvent the propensity prohibition by presenting evidence of our client's good character or of the victim's bad character. But again, let's be careful of that. Now, we can, as far as character of the witness, the rules, only allow character of the witness for truthfulness or untruthfulness. It's limited to that. Of course, we can always probe witness bias and witness prejudice and that sort of thing. But for the most part, the rules really have an exploration of a witness's character to truthfulness or untruthfulness. We can, however, attack through Rule 609. We can impeach the witness by criminal conviction. And, for that, we have to look at such things as what type of case it is, who is the witness, if it is our client, has a bit more leeway, and that the prior conviction is tougher for the government to bring a prior conviction if it is that of our client who's testifying. One of the very few instances where the federal rules actually benefit us, our side, in a small fashion. For the most part, the rules do benefit the prosecution. We need to also look at how much time has passed. Has the conviction been pardoned or annulled? And is it a juvenile conviction? If the prior crime is one for a dishonest act, then the conviction is coming in. The conviction is coming in. And if the informant has a prior that is for a dishonest act that matter, there's no need to go ahead and do a 403 analysis. That conviction is coming in. We have the right to bring it in, regardless of what the prosecutor says. So if you're talking about a conviction for fraud, false pretenses, etc., that's coming in. It is, however, subject to the 10-year rule. That is that a conviction has to be 10 years from the time of conviction or from the time of expiration of the sentence. Of course, here throws apart, with the courageous act of defying an oppressive system of justice. I always think about this picture here and think about the fact that, look at this police officer processing her there, and the amount of care and time he put into swapping his hair on that particular day. If dishonest act is not an element of the crime of conviction, then the conviction comes in only if it is a felony. And here's again the distinction that I drew before between a defendant and other witnesses. It can the prosecution can only use a prior conviction against our client if the probative value outweighs the prejudicial effect of the evidence. Prosecutors very conveniently ignore that subsection, again, very conveniently, and oftentimes judges are completely unaware of that simply because oftentimes they don't care because they're a client. Now, if it is another witness other than our client, then the felony conviction is coming in if the probative value substantially, unless the probative value substantially outweighs I'm sorry, I confused that there. The conviction will be used, and my apologies for that, against another witness that is not our client, unless the probative value substantially outweighs it's outweighed by unfair prejudice. Okay, now let's remember, of course, that the propensity prohibition covers prior bad acts. Let's remember also that we can use this 404B, and that is 404B permits, of course, evidence of prior bad acts if they come in to show motive, intent, modus operandi, identity, etc., typically used by the prosecution, but we can also use it in the right case against an informant, against a government witness, etc. And let's remember also that in 2020, this rule was changed to benefit us by now the prosecution not having to provide, written notice, even if we don't request it. So again, the rule has changed. The prosecution has to identify the bad act, articulate the non-propensity reason for using it, etc. Now, let's remember that in child molestation cases, as well as in sexual abuse cases, this is a rule that severely disadvantages, and that is that a prior, if the defendant, if our client is being charged with a crime of child molestation or sexual abuse under Federal Rule of Evidence 413 and 414, that prior can come in, and it can come in to show propensity. But also remember that the court that prior conviction is subject to 403 analysis. So if we're able to convince the court that bringing in that objection, that the prior is going to result in undue prejudice to our client, we can exclude it. In addition to that, the prosecution has to disclose to us if they are intending on using that evidence. Now, let's briefly cover another big objection basis, and that's improper opinion. Improper opinion can be both lay or expert. If it is lay opinion testimony, and this gives you a nice little framework on how to analyze opinion testimony. Let's remember that lay opinion testimony has to be based on the witness's perception. It cannot be based on specialized knowledge. It cannot be based on scientific or technical knowledge. That has to be expert testimony. The government, however, oftentimes will try to hide, will try to disclose, will try to present opinion testimony through an officer acting as a fact witness. They'll try to they'll try to Trojan horse expert testimony through that witness. You have to be very careful of that, because that is a favorite ploy of prosecutors. Now, for expert witness testimony, the requirements, of course, is that the expert has to be qualified. The evidence has to be helpful to a trier of fact. It's got to be based on sufficient facts or data, and it's got to be based on reliable principles and methods. And the principles and methods have to be reliably applied in this particular case. Now, arguments for us to object to prosecution expert evidence is that the expert experience is not relevant, that the experience is shallow, that the expert lacks recent experience, and that the expert has provided no methodology or guiding principles. Of course, the scientific evidence, expert evidence, even if it's not scientific, even if it's based on technical knowledge, is analyzed under Daubert. Let's remember that we need to keep objecting to a bunch of junk that the prosecution presents. Daubert requires 5-step analysis looking at has the theory or technique been tested, subjected to peer review, its rate of error, etc. Obviously, I don't have time to go into Daubert at length, but let's remember that a lot of evidence is coming in where prosecutors are using such evidence like bite mark evidence that is unreliable, and evidence and scientific evidence shows that it's unreliable. And the Champion has a number of really good recent articles that are included in the PowerPoint that you can take a look at that discuss the prevalent use of junk science in prosecution expert testimony that we need to continue to object to. Again, such things like bite mark analysis, hair analysis, footwear analysis, firearm analysis, etc. Okay, now as I'm wrapping up, I want to cover some objections here really quickly. Lack of authentication, and of course, for evidence to come in and for the authenticity to be established, the proponent must establish that the matter in question is what the proponent claims it to be. I'm not going to spend much time on this one, but the slide here outlines a number of different ways in which an exhibit can be authenticated by a witness. Lack of personal knowledge. This is another objection. Objection to the substance of the information, and this can come up in two different ways. If you know or if you suspect that a witness lacks personal knowledge, then request, prior to a witness even testifying on that topic, request a voir dire of the witness where you can show that in fact the witness lacks personal knowledge under Federal Rule of Evidence 602. If, on the other hand, the lack of personal knowledge is established on cross-examination, so this is not, you were able to foresee it, or, you were able to actually raise an objection prior to the evidence coming in because you foresaw it coming. If it comes during, if it comes out and you need to now deal with it in cross-examination, obviously what you can do is move to strike the testimony, and if necessary, move for a mistrial. Okay, objection, non-responsive. This is an objection that is actually, or say we're crossing the witness, we pose a question, and the witness is non-responsive. This is an objection that oftentimes some lawyers are reluctant to make because some lawyers believe that that is not good to go ahead and show that we're not in control of the witness. Be it as it may, just keep this in mind. If you have that agent on the stand and the agent is, it gives you a runaway response to your question, you can respond, you can object to it being non-responsive, and you need to make the judgment call as to whether you should be entering that objection or not. As far as a prejudicial objection, of course, you look at, is the evidence relevant, and then you look at, is that relevance substantially outweighed by danger under Federal Rule of Evidence 403. Then if it is, the evidence should be excluded. As far as whether something is relevant or not, unfortunately, the rule very much favors the prosecution. The standard, the threshold of relevancy is very low. I deal with that at much greater length in prior lectures. But when it comes to prejudice, certainly the critical thing is that, an item of evidence is unfairly prejudicial if, a jury, if that evidence put security in risk of making a decision based on an improper ground, typically an emotional ground that has nothing to do with whether the defendant is guilty or not. Okay, as we're wrapping up here, another one of our objections is speculation. And, and this is one that you can frequently make because, agents, especially for some reason, DEA agents are love to speculate. So certainly, remember this objection here when you have a prosecution witness. Speculative evidence is objectionable on its own, but certainly can be objectionable because the evidence that's coming in ends up confusing the jury, misleading the jury. So you also want to go ahead, oftentimes enter an objection that is just not speculation, but you also argue 403, Federal Rules of Evidence 403, of course, that being prejudice. Okay, so, so with that, we're coming to the end of the presentation. I cannot thank you enough. I cannot thank you enough for what you do. I cannot thank you enough for objecting, for having the courage to object. And again, when in doubt, let's object. And, let's remember, the example by individuals like Nelson Mandela, lawyers, colleagues of ours like Nelson Mandela, who had the tenacity to object. And with that also, should you have any questions, if you want to reach out to me regarding an evidence question or whatever, please do not hesitate to reach out. And with that, I cannot thank you enough. I cannot thank Vanessa enough for inviting me to speak to you. And I hope you can join us for next month's presentation. And next month, we're going to be dealing with an update to the Federal Rules of Evidence.
I just want to say I can't thank you enough, Rene, for presenting us with another incredible part of the series. We couldn't be more pleased to have you. So thank you again for all the incredible information. And I'm sure our viewers really appreciated the theme of today's PowerPoint overall with objections to. Great theme. I love that. And all of those photos you included on that theme. I just want to thank Justice Text again for being our sponsor again today.